Great news, guys. YouTube made some upgrades. Stupid YouTube. On my last nerve. YouTube is on my last nerve. All right. Speaking of last nerve, we're about to watch a disciplinary hearing for an attorney in Pennsylvania. And it's going to take multiple days to get through this hearing. It's not short. It is really interesting, though. Spicy. Even. And we won't get an answer right away. This is one we're going to look at as it develops. But he accuses lots of people of lots of things. So, before the trial starts, in front of the disciplinary board, so it's, I guess you don't call it a trial, disciplinary hearing, a long, full disciplinary hearing with witnesses and everything, evidence. Before, we're just gonna listen to a piece of some of the arguments before the hearing even starts. And this one piece that we're gonna watch is his lawyer wants to subpoena a judge, and nobody likes this idea. So, Michael, fix YouTube. Make them knock it off. They're bullying me. Yeah. So here we go, guys. This is Pennsylvania. Woohoo!
I think a big distinction is what you spoke of with Barton. What's judicial conduct versus private conduct?
Okay. So, the three people to the left of your screen, that's the panel of judges for this disciplinary hearing. The lady in the green sweater beside them is just the court reporter, I believe. Across from her, the two male, they're both lawyers. The one furthest away from us, he's the defendant. That's Attorney Bell. All right, now the lady in the middle, she's the bulldog. She's the attorney for the Office of Discipline, whatever, Attorney Discipline, ODC or something like that. We'll hear them say ODC a lot, I think. And then this is a different attorney at the bottom, but I can't exactly figure out for who. But I think it's for one of the judges that he wants to subpoena. So I think that's the judge's attorney, but I'm not 100% sure on that. So now we're just going to listen to him trying to get a judge in first, and then we'll start the real hearing.
Here, as opposing counsel said, there were three other judges, more senior to Judge Wallace on the panel, another number of complaints. The complaint, the substance of it had to do with what happened in the trial court, and specific allegations, especially ones that deal with Judge Anders and the allegation that my client lied about his recusal. That had nothing to do with the appeal. So the fact that this came after the deliberations were already concluded, the fact that some of the allegations didn't have anything to do with, they weren't deliberative in character. I believe that alone should allow their class should be denied.
Serious though, America is about to turn 250 this year. Where would you rather be? What state would you rather be when America turns 250? Pennsylvania. Where in Pennsylvania? Philadelphia. That's where y'all gotta be. In July. We should go to Philadelphia. Oh man, that place is gonna be crazy. It's gonna be crazy great.
Yeah, I think, as we said, when it comes to this private ODC complaint, but it come in, the allegations against Mr. Bell, I think what we said about the four corners, and that anything that the judge used in context, I believe we should use it. It should be allowed to use for, my client should have full ability to defend itself with anything anything that's inside that complaint. or suggested in the complaint. So I believe it opens it up. She waives the deliberative process.
I'm not going to find a waiver of deliberative process. So I think the question, Mr. Duckett, is whether you'll be able to confine your questions if the motion is denied in part, whether you'll be able to confine your questions to events that occurred after that opinion was rendered.
Yes.
Okay, so that means there's not going to be any cross-examining of the judge about what she wrote in the opinion or why, right?
There will be cross-examining about what the judge, what she wrote in the complaint. So some of what she wrote in the complaint does tie into her opinion.
Well, I think...
Yeah, I can give an example.
Sure.
So there's an allegation, or there's in the complaint that my client said black jurors are going to serve. There will be black people on the jury. Black people are going to serve on the jury. That is something that she put in the complaint. I believe that my client has a right to defend herself against, but that's also, I believe, something that she.
So do you have the actual complaint? Has that been provided, or you just have the DB7?
Yes, we have the ODC complaint.
Ms. Ammons is saying no, you just have the DB7.
Boys, I'm very disappointed in you. You're only allowed to talk about Genos and Pats when you're talking to outsiders. Come on now. We don't want no tourists coming to our cheesesteak shops.
First of all, we do not have discovery in this system. Mr. Duckett, and I don't want to intrude in his argument. Mr. Duckett is making a lot of assumptions in this matter. Yes, we did receive a letter from Judge Wallace with her opinions attached. ODC does their own investigation. When we sent Mr. Bell the DB7, that was based on our own investigation and the opinions that Judge Wallace attached to her letter to us. Judge Wallace never said, well, Mr. Bell said.
You know what else about Philadelphia I found out yesterday? Recently. Alec Boehm is still on the Phillies. I thought he was traded like 2 years ago. And I was watching a game in a bar, and there's Alec Boehm's big smiling face right there on the screen. I couldn't believe it. I'm so excited. I'm so happy. I want to marry him twice. Absolutely. I know he's a jerk. I know. But I guess if you look at my track record, him being a jerk is probably an upgrade.
The black juries, whatever Mr. Duckett said about black juries, that didn't come from Judge Wallace. That came from our own independent investigation. That came from the pleadings that Mr. Bell filed in the Court of Common Pleas. Mr. Bell, Mr. Duckett, they don't know how we came to that conclusion. We do our own investigation. He doesn't know what Judge Wallace said. It's based on our own investigation. He makes a lot of assumptions. And no, he doesn't have the complaint because we don't have discovery in the system. He's not entitled to it.
So right. So, Mr. Duckett, am I right? What you have is the DB7 that came from Office of Disciplinary Counsel. You don't know what specifically Judge Wallace sent in that prompted whatever went into that letter.
We don't know what she specifically said in. However, the DB7 says that Judge Wallace said that she said it.
Okay. Well, if Judge Wallace were testifying and you were able to ask her what she sent, and she gives testimony along the lines of what Ms. Feigenbaum just said, there was a short letter that said, "I'm sending you a copy of the attached opinion." What then?
What you said?
What then would be for you to ask her about?
Well, one, it would be great that we could see the letter, and that's part of what I'm sorry. You said what?
what further questioning would you have if Judge Wallace establishes basically what Ms. Feigenbaum just represented, that the complaint was just a short letter attaching a judicial opinion and bringing it to ODC's attention?
One, we'd like to see it. And then also, that letter off, I think after seeing it, we would know what questions. I think it would be better. Without seeing it,
Well, I'm not sure that you get to see it, Mr. Duckett, if that's not the procedure, and at least nothing is before the committee in terms of that. So all that we can do is rule on this motion of quash. And I guess what I'm saying to you is, as I read the Pennsylvania case law about the deliberative process and judicial testimony, it is not going to be possible for you to inquire into
Alec Bowe, he's on the Philadelphia Phillies.
the judge's process in reaching a decision. As you say in your response to the motion to quash, and as Ms. Feigenbaum and I were just discussing, there is this distinction about when things happen, and that at least that plurality opinion in the Barton case is saying that the deliberative process has to be before the decision was reached. So I think there's some daylight there about what happened after, but that's not a way to backdoor into asking the judge about what she put in her opinion and why. So my question to you is that if my ruling was going to be that she can testify, but you can't ask her about the decision that she wrote or why she wrote it or cross-examine her about statements that are made in it, would you still want to call?
still call her, yes.
And you'd be able to ask her questions that don't intrude on the deliberative process privilege the way that I'm articulating it.
There is one thing I just want to say that we spoke of with Barton that I think we didn't assert just yet. Is that it says information that's purely factual, even if decision makers use it in their deliberation, is usually not protected.
Yeah, but that's the argument in Lieber that didn't work, right? That we can't make that distinction when it comes to what went into the judge's deliberative process in reaching the decision.
Right. So when we talk about what goes into her complaint, our subpoena asks for emails and communications with Mr. Albert. That shouldn't be part of the deliberation.
They've represented that no such emails exist, so she can't bring with her something that doesn't exist.
Understood. We did also ask for them to deliver, which I think should be covered, that letter that she did write to ODC.
Is that right?
That's not a subpoena. No.
I don't, where is that? Where is that in the subpoena, Mr. Duckett?
I'm sorry, I thought it was in there. That's not.
Okay. So, but you're saying, so I guess what I'm saying to you, Mr. Duckett, is that the only appropriate questioning could possibly be what happened after the opinion was issued. Not the opinion itself, not the deliberative process that went in to the opinion. And so if there's still questioning that you need to do outside of those limitations, then that's what I'm asking you. Is there's still relevant testimony that you intend to elicit?
Yes.
Ms. Ammons.
Okay, I don't know if the panel wants to see the exact DB7 that was sent to Mr. Bell.
Mr. Bell included as one of his proposed exhibits.
Okay, so it's in my exhibit too, it's 54.
Yeah.
As I said, Mr. Duckett is making a lot of assumptions in regards to the complaint that was filed against him that was sent in by Judge Wallace. As mentioned before, Judge Wallace has a duty under the judicial conduct rules to report to the Office of Disciplinary Counsel any behavior of an attorney that may be deemed a violation of the rules. Judge Wallace did not say it's a violation of rules. She sent it to us for our investigation. That's the purpose of our office, is to investigate. We investigated. We received, Judge Wallace did not send the docket. Judge Wallace didn't send the pleadings that were filed in both the Miller and the Myers case. We obtained those documents ourselves. The statements that respondent made in those documents, in those pleadings, were included in the DB7. We did not receive that from Judge Wallace. What we received from Judge Wallace, again, are her opinions.
You asshole. I believed it was King Brendan.
That's what we received. We conducted our own investigation. Again, Mr. Duckett's making a lot of assumptions here.
Do you think, Ms. Ammons, that if Mr. Duckett were to see that letter, it might eliminate the need for him to call this witness?
No, I do not. And again, there's no discovery in this system, and that's 213.
Ms. Ammons, when you subpoenaed Judge Wallace in your case, what did you disclose were going to be the subject of her testimony?
Well, I subpoena all judges because we are requested. If I put my potential witness list and I subpoena all judges. I did not subpoena Judge Moreno, who I decided I was not going to call because he's no longer in our jurisdiction, so I could not subpoena him. But any other case I had, I subpoena judges. And I was going to initially subpoena her about her opinion that she filed. But after speaking with counsel, I determined that I did not need her. All I had to do was present her opinions and ask for judicial notice of her opinions.
Thank you,
So
Slinger. Thank you.
she was on my witness list. I had a vast amount of people I was going to call, not a vast amount, but a number of witnesses that I ended up not calling just because I put her on that witness list. But I wanted to cover myself, so I subpoenaed her.
You see, though, how that makes it a little more difficult for you to argue that the testimony is not relevant.
I don't see that. I don't see that at all. Nope.
Okay.
After I spoke to counsel, I came to understanding. I talked to my counsel in charge, and we determined it's not relevant because we have her opinions. So no.
Yeah, I think that
Because based on what they put in their subpoena, that's not relevant at all. And I was going to question her about her opinions, not about what was subpoenaed, the documents that they subpoenaed. So it's totally different.
Well, again, the documents there's been a representation made that the documents don't exist, right? But the request for the documents suggests that there's some belief on the part of Mr. Bell that there's some bias, I would say. And whatever went into the issuance of the opinion is protected by the deliberative process privilege. But so the only universe that we're talking about is what happened after that. And you're saying what was in the letter accompanying the DB7, Ms. Ammons, but Mr. Duckett hasn't seen it, right? And so
You said King Brendan, and I believed it full, because I trust you when you tell me stuff about Australia. But if you would have picked maybe, I don't know, King Bernard, I wouldn't have believed you.
So the question is, what ability does he have to develop the factual record? And I will just say that I think it is a difficult situation where ODC puts judges on their witness list. You call Judge Anders,
Right.
You subpoenaed Judge Wallace. There was not a motion to quash, and I hear you say that that's because there was a discussion, but Mr. Duckett, who's subpoenaed the same witness that you subpoenaed, if he doesn't get to call that witness, I think that there's some question about him having a full opportunity to develop his factual record. If he can do it within the confines of the deliberative process.
And I understand that. Could I just offer up? I just wanted to respond briefly because I think part of the misunderstanding here is there's reference to a lot of the allegations of his client's conduct. None of that conduct took place in front of Judge Wallace. It's referencing things that were part of the record below, perhaps. But Judge Wallace is not a witness to any of this alleged conduct. She is not a factual witness, and she honestly, as I think Ms. Ammon said, to the extent that she is, it's her opinion in deciding the appeal. That's really it. So I find it difficult to understand what she could actually testify to that isn't hearsay. She was never a witness to any of the alleged conduct that's at issue here.
Mr. Duckett,
That's why I think she's we don't hear her during the trial. I like the color of her jacket though.
what is your sort of offer of
Not that
proof
matters.
about what is Judge Wallace going to testify to?
Well, essentially, when we read the DB7, it says that it's a complaint against you from the Honorable Stacey S. Wallace when opposing counsel, Ms. Feynman, when she says that it talks about factual allegations outside of her court, outside of her judicial duties, then I think it's relevant. How did she get that information? And what information did she provide to the ODC to say that my client is in violation of the
Pennsylvania.
rules?
This is from
What I
Pennsylvania.
want to point out, the trial court didn't file a complaint, nor did anybody else on the panel file a complaint, and it all happened afterwards. So,
It's all in the record already, right? Because you asked Judge Anderson.
right.
So if the testimony from Judge Wallace is what it's been represented to be, which is she didn't.
Oh my gosh, cutie pie. I wonder if that's the judge. I wonder if the judge made remember Judge Cutie Pie? Brett Martin? Anyway, Martha, thank you so much for the gifted memberships. I appreciate it.
Include any substance other than what was in her opinion, then what is it that you think
High
she's going to
five, Terry.
testify
Thank you.
Or if you get confirmation of that, is that the end? Is the only thing that you need confirmation that there was nothing else in the letter?
I believe the letter should be produced. I know that.
There's nothing before me
Right.
on that issue, so I don't think that's something that I can.
That is sort of messed up. The judge sent in a complaint to the disciplinary council here about this attorney, right? He's not allowed to see that letter. So the disciplinary council, the lawyer on the right, the bulldog, the one in the middle, opened up an investigation on him because of this letter and other things. He's not allowed to see the letter. No more ponytails. Welcome.
Can I point out, if there's anything, and we have a policy in our office, if there's anything that we have that's exculpatory, that will lead to helping his defense, it's a policy of this office to turn that evidence over. Whether or not we call the witness or not, it's our policy to turn over any statements that
Drunken nothing I do will
potential
stop it
witness
or
or
not
non-witness produces to this office, then we produce that
bought.
to the.
You just start up another one in 2 seconds. It makes no difference. It doesn't help. It doesn't hurt. It doesn't do anything. Twitch has to take care of that itself, and they know how. They just don't.
Responded, irregardless of what 213 says, if it's a culprit, and it's not. Again, Mr. Duckett is stuck on. Well, Judge Wallace said these allegations. He doesn't understand that these allegations in here that were, yes, Judge Wallace filed a complaint. Judge Wallace was concerned about the conduct because it was before her in the Commonwealth Court. So she reported it. It doesn't matter that Judge Anders didn't report it. It doesn't matter that the city solicitor's office didn't report it. That doesn't matter. It came before us. So we conducted our own investigation. And as I said before, we're the ones to actually get the documents in both the Miller and the Myers cases. And we presented this, our allegations that we put in this DB7. It was sent by Judge Wallace, but nowhere in there it says these are her specific allegations. These are our allegations, and we gave Mr.
Ms. Ammons, I think the issue that we have and the source of the problem is that that letter is not in the evidentiary record. And I think in the absence of that letter, and anything in the record about what actually was the complaint that Judge Wallace made, that's what is opening up the potential need for this questioning from Mr. Duckett's perspective. So, I mean, that's a choice, but the choice might have the consequence of needing to have the testimony about it.
Tequila Sunrise is better,
Mr.
by
Duckett, you were
much.
going to say something else.
but it's better.
No, I do have questions that will fit into your parameter, just to confirm that wouldn't be about the deliberative process.
But I guess what I'm hoping to understand, Mr. Duckett, is what do you think Judge Wallace has knowledge of and is going to testify about that is beyond the opinion that she wrote? Because I'm saying let's assume that the answer to your first question about what was in the complaint is what's just been represented by Ms. Ammons and Ms. Feigenberg, right? Then what? You don't get to ask about the opinion.
Understood.
So what would you ask?
Part of our defense is still selective prosecution as well. And then whether, so I believe there's some questions with respect to that as well.
Yeah.
If I may, I would just have to say, I'm not entirely sure what Judge Wallace has to do with the prosecution of the choice to proceed. So I frankly don't know how that would be, again, relevant.
Well, I don't know either. But she did send the complaint. She was on ODC's witness list, and the deliberative process privilege in Pennsylvania seems to stop when the decision is issued. So I think it would be difficult to deny Mr. Duckett any opportunity to inquire into this. It might be a very short examination if the answers to the questions close off these open questions that may be floating out there, but I think that's where we are given the information that is out there and not out there about this. Let me just ask you one other thing, and I think Mr. Duckett has agreed with this, but in terms of the judge's availability to testify, obviously she's sitting.
All right, Drunken, keep your damn screwdriver, but splash that grenadine in there just to make it look like a tequila sunrise.
This week, but you said that she would be willing to make herself available if the committee determined that her limited testimony was appropriate at 3:00 tomorrow. Is that right?
Yes, Judge Wallace believes argument should be done by that time. I do hesitate to say with any certainty that it would be. I know they can run late, but she does believe that she would be done with tomorrow's argument day by that time.
Well, I'm very.
You're gonna love them, Monica.
I think
So
that
good.
obviously her schedule and her duties as a member of that court take precedence over anything that is happening here. But since she believes that she would be able by then I think Mr. Duckett is saying he has no objection to accommodating her schedule. Correct?
Correct.
Okay. So the ruling that I'm putting on the record now, and that will be the subject of a written decision that will be submitted in accordance with the disciplinary board rules, is that the motion to quash is going to be granted in part and denied in part. It's going to be granted as to the documents that have been requested that Judge Wallace through counsel is represented don't exist, and it's going to be granted to the extent of the deliberative process privilege, which, as I've explained, means that there can be no questioning about Judge Wallace's deliberative process or the decision that she wrote or anything that went into that decision. The questioning is limited to events that occurred after the decision was issued, and that otherwise the motion to quash is going to be denied, and we will accommodate Judge Wallace's schedule to testify at 3 o'clock or if later when the argument session is completed for the day.
All right. And briefly, is that in person or would that be accommodated through WebEx?
I presume she is not in Philadelphia, and that I don't know where they're sitting.
I believe they actually are in Philadelphia.
Well, what would be most convenient for the judge?
For timing, a remote appearance would probably be best, but if it does need to be in person, I can certainly confirm with her shortly. So.
I mean, I'm inclined to accommodate the judge's convenience here because I think that we are
Hi, Debbie.
we are imposing on her, and so any objection if it's more convenient for the judge to appear by WebEx?
No objection.
Okay, Zammons?
I have no objection.
Okay, so it's entirely up to her, whatever she would prefer. And just to make clear, Ms. Weigenbaum, I mean, I do take very seriously the limitations on judicial testimony. My ruling is really because of the unique circumstances that we had present here.
I hate tequila sunrises. Not drinking them, just... I worked at this bar once where there was a high turnover rate among the servers, and I had to continually keep teaching people how to make tequila sunrises, which are 3 ingredients. Super simple, unless you want to count the ice. 4 ingredients. And I just do not understand people. It's like they've never touched alcohol before in their life, and they're just, ugh. I had to teach them that and old fashions, but thank God, hardly anybody ever ordered an old fashioned. So I just made them all. Just let me do it. Just go away. But they couldn't get it. The new people could not get it, and it was very, very frustrating for me. And I just don't like them now, but I like drinking them.
And all the reasons that I've explained, and I intend to hew very closely to my ruling in terms of the questioning, and will sustain any objections that go beyond what I've said. And I'm taking Mr. Duckett's representation that he has relevant and appropriate questions to ask the judge that are within the scope of my ruling, but if we exhaust those, then we will end the questioning at that time. Please do.
You solemnly swear or affirm the testimony you're about to...
Okay, so they can subpoena. They can subpoena the judge. That whole thing was trying to get it so they wouldn't subpoena the judge. And they ruled, yeah, if you're going to be putting letters in that she wrote, then she can be subpoenaed. Now, she's not coming yet, all right? This is the start of the hearing right now. Attorney Bell is in the hot seat, way at the top of your screen. And then the bulldog is going to start questioning him. She's going to get yelled at a lot.
You ever be the truth, the whole truth, and nothing but the truth?
Yes.
Mr. Bell, you were admitted in June of 2018 to Pennsylvania, correct?
Yes.
Okay. Now, the first case that I'm going to talk about is the Brianna Murphy case, and that was filed on May 11th, 2020. Do you agree with that?
I don't know the exact date, but that sounds accurate.
Well, why don't you look at ODC 1?
I agree.
Okay, thank you. Now, before that, okay, let me jump ahead to the Miller case. If you want to get refresh with the number or when it was filed, that was filed in October 2019. Would you agree to that?
That sounds accurate.
Okay, and the Myers case was filed in October 2019 as well, correct?
The same date.
Okay, so when you filed,
You know how everybody's gifted with special talents, Drunken? Like everybody has a talent. They do really well. Maybe not the best of the best in the entire world, but they do it really well. I metabolize alcohol. I can handle my liquor. I can drink heavily and be perfectly fine. Not driving. I'm not saying I'm going to get behind the wheel of a car. But I'm not going to fall off my chair and sleep with the guy beside me. It's just one of my talents. Alcohol is my friend.
all these cases, you were, the Millers and Myers, you were a member of the bar approximately 1 year, correct? 1.5 years, correct?
That sounds about right.
Okay. And when you filed the Murphy case, you were also maybe a year or two, close to 2 years, you were admitted to practice law in the Commonwealth, correct?
That sounds about correct.
Okay. Now, before you filed those cases in 2019 and 2020, did you take any trial advocacy CLEs?
I went through trial advocacy in law school.
Okay.
I tried actually 2 cases before that. Yeah, I told you.
What I'm talking about, Mr. Bell, is when you were, after you were admitted to the Commonwealth of Pennsylvania.
And ask him to respond.
Yeah, Ms. Hammonds, let him finish his answer before you ask the next question.
I don't know where it stopped. I'm sorry. So,
My question to you was,
okay,
before you filed these cases, and I'm not talking about before you were admitted to the Commonwealth of Pennsylvania, I'm talking about after.
okay.
Did you take any trial advocacy CLEs
No,
between your legal education courses?
no, I read the case law.
Okay. Now, you just testified that you took, in law school, you took some trial
Not
advocacy.
officially trial ad, but we used to conduct mock trials, and rules of evidence and stuff like that. I didn't officially join like a trial ad team where we competed in competitions, but I understand trial advocacy. And I understood it before I was a lawyer because I studied it on my own and I paid attention in law school.
Okay. Now, you filed the Murphy case, which is ODC 1, that's the docket, as I mentioned, in May of 2020.
Hold on 1 second, let me find these exhibits or not. Or yeah, easy.
No, but before we go to that, while you're looking for that,
Buttery nipples used to be
I
called
understand you said
butterballs.
that you.
I like butterballs better.
Put this table up, if you have more space.
I got it.
Yeah, I think that's,
Well, if you move the white binders, because we're not using those right now, maybe that'll give him some room. Or what you,
I think
Mr. Bell, why don't you put those binders on that chair? And then right now we're doing 1 through 2024. So you can put the other binders.
Look at all those binders.
If that helps
Oh
you.
my gosh.
yeah, and it's fine if you want to use that table over there, we can move that over and,
All right, thank you.
do that. You are?
This is 14 and 1 and 20.
Sorry.
Maybe it's big bite here.
And this woman is going to keep making him go through all the different binders. Like, she's going to keep the next question is going to be from a different binder, and the next question is going to be from a different binder. Everybody gets confused.
So it's number 1.
Yeah, they are. Yeah, all right.
And before we go to ODC 1, I do have a few more questions in regards to your experience. In the Court of Common Pleas, between 2018, June 2018, through, let's say, 2022, how many cases did you try in the Court of Common Pleas in regards to civil rights?
I don't know. I don't recall.
Would say 4 cases. Does that sound right?
I don't know. It wasn't a lot.
It wasn't a lot. Okay.
Yes.
Is it less than 10?
Yeah, in that time, absolutely, in that time period.
How about less than 5?
No.
No?
So, all right, you talking about cases in which I was entered or cases where I was co-counsel with other people?
I'm asking cases that you were entered.
You didn't
as
say
the-
entered. but-
Okay, cases
Hold
that.
on, hold on. Don't argue with the witness.
I'm not.
We're gonna just ask the question, answer the question.
My question to you was, between 2018 and 2022, how many cases in a court of common pleas were you attorney of record?
Wasn't many.
And my next question was it less than 10?
Yes, I answered that.
And was it less than 5?
I don't know.
Okay. In the federal court, do you recall how many cases between 2018 and 2022 you entered your appearance?
No, it wasn't a lot.
Was it less than 5?
I don't know.
Does Braxton versus Philadelphia District, does that sound familiar? That was filed in 2020?
I didn't hear you.
Braxton versus Philadelphia District. District Attorney Larry Krasner and the Attorney General of State Josh Shapiro. Does that sound?
We're finally having a conversation in chat that I'm in love with, and I have to go pick up my son from work. I'll be right back. I'm going to get my daughter to come in here and keep everybody in line. But y'all are making me really thirsty, and I have a live stream in 8 hours, and I absolutely can never drink before a live stream because my mouth, there's no filters anymore. When I drink, there's no filters, period. I just don't have filters, and I would get canceled tonight. I would get canceled. So maybe it's best that my daughter comes in here and I don't have to watch this chat anymore, because really I'm getting really thirsty. Just it would be a great stream if I could just drink while I stream. We would have so much fun. I'm gonna get my daughter to come in and take care of everything, get my son, and be right back. Okay? Behave. Or don't. She'll boot you. She's strict.
Familiar?
What's the first name of the plaintiff?
Frank.
That was a 2254.
This was filed.
That wasn't a, oh, I'm sorry.
This was a habeas corpus.
2254.
Okay. And that was filed in May of 2020.
Yeah.
Okay. How about Jay's Copeland? That was a habeas corpus filed in June of 2018. Does that sound familiar?
That sounds correct.
Okay. And does this sound familiar? Ryan Quarles, which is a diversity tort non-motor vehicle case that was filed in June of 2021. Does that sound familiar?
I object to the relevance. I'm not sure how this is probative.
That sounds about accurate.
Okay. And how about John U-Haul Bender versus the District Attorney of Philadelphia?
I don't remember.
Okay. So you agree it's not many cases that you were, that you tried between 2018 and 2022 in the federal court system?
Where I was lead counsel, my appearance was entered. That's accurate.
Okay. Now, going back to ODC 1, this case was filed May 11th, 2020, correct?
It says that on there. That appears accurate.
Okay. Now, also, it says you're listed Aaron Bell, and also a Lucas Nesamento. I don't know if I'm pronouncing his name right. He's listed as counsel, correct?
It says it on the paper.
Okay. And it also states that his representation was terminated on June 29th, 2021.
It says that.
Okay. You agree it says that?
It's on the paper.
Okay. Now, after Mr. Nascimento withdrew his appearance, which is on base stamp number 7, says that he filed a motion to withdraw and it was granted. Base stamp number 7. Same exhibit, not exhibit 7. Base stamp number 7, exhibit ODC 1.
Which line?
39. Order that the motion to withdraw. So you agree that he withdrew his appearance,
Yes,
correct?
I remember that now,
Okay,
yes.
good. Now, in this matter, you filed the original complaint, correct?
Yes,
You filed a first amended complaint.
and the third amendment complaint too,
You filed a second amended complaint,
yes,
and then you filed a third amended complaint.
yeah.
Okay. And the third amended complaint, which is ODC 2D, that was the one where Lieutenant King and Police Officer Sabrina McCoy, they were the only 2 defendants left in this matter, correct? It's ODC, I'm sorry, it's base stamp number 70.
Wait, number 70?
Yes.
This is the complaint that I filed, yes. This-
Okay. And as I said, you agree that Lieutenant King and Police Officer Sabrina McCoy were the only 2 defendants left, correct?
No. That's not accurate.
That's not accurate?
No,
Okay.
we sued Lieutenant King in her personal and official capacity.
Okay.
So there's a difference between the two.
Okay, so ODC 3, you agree that's a motion that you filed, correct?
Yes, for the partial summary judgment, yes.
ODC 4, you agree that's the motion that the defense filed, correct?
It looks like it. Yeah, if it's in here, that's it.
ODC 6, ODC 5,
Wait, hold on. You said 6?
I went back to ODC 5.
Okay, I'm at 5.
Okay. That's the order entered by Judge Moreno, right?
It appears to be, yes.
Okay. And that allows you to take depositions of Defendant King and Francis Healy, correct?
After the sham affidavit, yes.
Okay. Now, ODC 6, that's an email, you agree that's an email that you sent to Miss Janikowski regarding King's deposition?
Yes.
Okay. ODC 8, I'm sorry, ODC 7 is numerous an email chain. You agree those are the emails that you exchanged between Mr. Jakowski and yourself, correct? If you look through the pages, you can have time to look.
Thank you. Yeah, I remember this, yes.
Okay. ODC 8. You agree that's another email that was sent between you and Ms. Janikowski?
Yeah, I remember this one.
Okay.
Yep.
Now, after these emails were exchanged between you and Ms. Janikowski, on June 8, 2022, Francis Healy's deposition was taken, correct?
Remember the date. And, it's Miss Jankowski, not Kowalski. Jankowski.
Okay, was the deposition taken on June 8, 2022 of
I don't know the
Francis
date,
Healy?
but there was a
Okay.
deposition of Mr. Haley.
Do you recall the P4D that we sent? The petition
Sorry?
for discipline? Do you recall the petition for discipline that we sent to you?
I mean, I didn't look it over recently, but I know it's in there.
Well, if I told you that you admitted that that's when the deposition took place,
It's the date of the deposition. I'm not
Okay.
disputing that.
Well, I'm going through this, Mr. Bell, because we didn't reach stipulation, so I have to do
That's
this.
not a question.
That's not the answer.
Let's ask a question.
And you agree that you eventually took Detective King's deposition, correct?
She's not a detective, she's a lieutenant.
You agree that deposition was taken, correct?
Yes.
Okay. On June 23rd, 2020?
I don't know the date, but yes, if you say so, yes.
ODC 9? Is that the defendant's motion for summary judgment?
Yes, it is.
Okay, and you also filed a motion for a renewed motion for summary judgment, which is ODC 10, correct?
That is accurate.
Okay. Now, both you and the defense were allowed to file renewed motions after the depositions were taken. Judge Rubino allowed you to do that, correct?
That's inaccurate as how you described it. Because he denied both of the first summary judgments without prejudice by how the law works. After the depositions, then we had the right to renew or otherwise file summary judgments because the record was closed at that time.
ODC 11, is that your motions for sanctions? ODC 11?
Hold on. I mean, there's volumes. It appears to be, yes.
Okay. ODC 12 is,
I think
it might be the next book.
14 was like.
Do you have a base number?
14, both.
Base number is 459.
All right, here, you can do mine. Yours, three.
Yeah, 12 is not in at least some of these binders, but
12 is not in the binders?
not in my binder, but it's in two of them, so we'll be all right.
Yeah.
All right, I found it.
Well, I'll make sure you get 12. I don't know why it's not in there.
It's a lot of pages.
I know.
Yeah.
Please don't.
It is a lot of pages, and I apologize for that.
I'm ready.
I'm at exhibit 12.
Okay, and you agree that's the motion that you filed on behalf of your client for sanctions in association with Francis Healy's March 7th, 2022 declaration?
Yeah, and it's
Thank
not
you.
just Francis Haley though.
I said in association, I'm reading your thing, thank you.
Okay.
And also with that motion is the attachments, correct? That you filed.
All right, give me a moment, please. It appears to be.
ODC 13, which is base stamp 755. That is your second motion that you filed on July 30th, 2022 to impose sanctions. Again, in association with Francis Healy's March 7th, 2022 declaration with attachments.
Correct. I think I made a mistake as far as exhibit number 12 though. Because the exhibit number 12, I think that was the motions that I filed about Derek Kane ejecting 129 times at the deposition. I don't think specifically Haley was in that one.
Okay.
Clarify, but yes, this is Haley for the sham affidavit.
Now, in your motion, ODC 13, 756, you said is a motion to impose sanctions on defendant King and her counsel for submitting a sham affidavit, correct? And exhibits. You filed that, correct?
Hold on. No, where's King at? I'm sorry, I'm confused. We are at 7:56, correct?
7:56.
And you said this is.
I'm reading your
All right,
your
gotcha.
your
Yeah,
headline.
yes, I filed this. Yes, I did.
I'm gonna backtrack a little bit. Can you get out? Can you get out the petition for discipline, which is 56?
I got it. Here.
And when you get to ODC 56, go to base stamp number 2129. It starts with paragraph 19.
I'm sorry, can you tell me the page number again?
I'm sorry, 2129,
Thank you.
paragraph 19.
I'm there.
Okay, and paragraph 19, that is a email that you sent to Ms. Jakowski.
Yes, it is.
And on the next page, 2130, and that's your statement that you made to her, correct?
Yes, it's an accurate statement, yeah.
Okay.
Oh, I'm sorry, Ms. Hammond, so this is the email being quoted in the petition
Correct.
for discipline, right?
Correct. That's an email that he sent to her. That was quoted.
Okay, so you're not referencing the actual email, you're just referencing.
I'm referencing what's in the P for D.
Okay.
That was a quote from the email. I'm asking him, was this the email?
I'm
The
just
quote in this email, was that the quote he made? I mean,
I'm
what he
just
said.
asking whether the email is gonna be in the record or not.
No, it's not. Okay. Okay, next is ODC 14. I'm sorry. I have to get these.
You're fine. I just wanted to give a heads up. I think we're moving on. So,
I didn't hear you.
ODC 14.
ODC 14.
Which one's right? Okay, it's fine.
Date stamp 818. Are you there, Mr. Bell?
It's just- All right, I'm at 14.
Okay. And is this the respondent's August 25th, 2020 motion for sanctions pursuant to Rule 11? Plaintiff's motion, I'm sorry. Plaintiff's motion, this is your motion, filed on behalf of your client, for imposition of sanctions upon attorney Jenna Jankowski for advancing patently frivolous and materially false representations to the court in her motion for summary judgment.
Yeah.
Now, and you filed this after you sent an email to Ms. Jankowski which you just admitted that was the email in the P for D, asking her to withdraw her summary judgment motion.
That's required by Rule 11, yes.
Okay. So you filed this after that email?
Yes, I did. I gave her the 21 days that the law say you have to do in order to file the Rule 11 motion.
Thank you, Mr. Bell. And that's and all these attachments are what you filed with the court, correct? That's attached to ODC 14.
Yeah, I wanted to give the court evidence for my motion, yes.
Now, ODC 15, which starts with Bates stamp 1261.
Give us 1 second.
I'm sorry.
You said, what number?
15.
If we had bigger binders,
14 was by itself.
15, I see.
You see 15?
Yeah. Yeah.
Okay.
I'm at 15.
okay, 15 is the defendant's August 25th, 2022 motions for sanctions against you, correct?
I mean, it appears to be, yes.
Okay, ODC 16. Okay, now that's Judge Rebrano's order denying your motions, correct?
It's Judge Rubino, yes, that's accurate.
And granting the defendant's motion for sanctions against you, correct?
That's accurate.
Okay. And Judge Rebrano sanctioned you in the amount of $5,232.50. Is that accurate?
That's accurate.
Okay. Did you pay those sanctions?
Yes.
Okay. And when did you pay them?
I don't remember. It was paid.
Was it after your appeal?
I don't know. I don't remember.
Okay. Now let's go to ODC 17. This is Judge Rebrano's second order of that day, September 22nd, 2022, where the defense motion for summary judgment is granted and plaintiff's motion for summary judgment is denied. Do you see that?
Yes, I see it.
Okay. And ODC 18. That's Judge Rebrano's order stating that the clerk of court shall mark this case as closed, correct?
Yes.
Now, let's go to ODC 19. This was filed on October 4th, 2022. This is a motion for reconsideration. And let's go back to Bates stamp 1397. I'm sure, sorry, go back to 1396. Lucas T. Nascimento filed this, which you told us, correct, in your answer to the DB7 and the answer to the petition for discipline?
I don't know what I said then, but yes, Lucas filed this motion.
Okay, you're saying that you didn't file it, Lucas
It's on
filed
the
it.
docket that Lucas filed,
Okay.
and there's nothing wrong with his motion. It was pretty good, actually.
Okay.
Yes. Lucas
Now-
filed this.
Did Mr. Nascimento, did he have your permission to file this motion for reconsideration?
Of course, Lucas was always on the case.
Okay, that's not my question. Did he have your permission?
He had me and my client's permission to
Okay.
file this.
Now, although he had your permission to file this, even though he withdrew his appearance about a year before then.
If you know, yes, that's accurate. However,
Okay.
he was always on the case. he withdrew his appearance because he had some family issues and he couldn't help me with the case. But once those issues were resolved, he got back on the case. Lucas has always actually been on his case. He just could not satisfy the duties to reply to stuff, and he got off the case.
Did Mr. Nascimento, did he enter his appearance again?
In federal court's not like states. You
Okay.
enter your appearance in federal court by filing a motion. States, you gotta enter your appearance before you can touch anything. So in federal court, you enter your appearance by filing a motion. That's how it's done.
Did he file a motion?
You're looking at the motion.
This is a motion. His motion for reconsideration is his motion to re-enter as an attorney?
In federal court, he didn't even have to file that motion to withdraw. I explained that he filed the motion to withdraw because at that time period, he was not going to be involved in taking care of the case and the client. He had to deal with personal issues. He entered his appearance by merely filing this motion. That's how it's done in federal court. It's not like state, it's different. So he didn't even have to file that motion to withdraw. But again, as I said, I was going to take care of it for the time being due to his issues.
Okay, so again, he had your knowledge and permission to file this motion for reconsideration.
I said that, I answered that, yes.
Now, let's go to ODC 20. And that's plaintiff's motion for attorney fees. And this again was filed by Mr. Nascimento. I don't even know if I'm pronouncing his name.
Nascimento.
Nascimento.
It's like Nascimento.
And this was also signed by your counsel now, Mr. Duckett, correct? 1405. Look at Bates stamp 1405.
Yes.
Okay. Now, Mr. Duckett's name never appeared on the docket, correct?
That is accurate.
And if you turn to page 1402, under outline, it says lead counsel for plaintiff Aaron Bell presents a request for reasonable cost. You see that? Right under outline?
Yeah, see that.
Okay, so you agree that you were lead counsel in the Murphy case?
Yeah, I mean,
Okay.
yes, on the docket, absolutely.
And then the deposition of Francis Hilly, under that it says attorney for plaintiff Aaron Bell received an invoice from the company. The galley deposition trial amount of $1810. And in this, you're requesting costs for that, correct?
Yeah,
Okay. And also in this motion for costs, Mr. Nascimento, I hope I pronounced that right, he's asking for attorney fees and reasonable costs, correct?
yes, it says so.
Okay. And Mr. Duckett, who did not even enter his appearance in this matter, is also asking for attorney fees.
It says that, yes.
And Mr. Nascimento and Mr. Duckett, they filed this motion for costs with your knowledge and permission?
Yeah, they filed an motion for costs. It was totally appropriate, yes.
Okay, that's not my question.
All right.
Did they file it with your knowledge and permission?
Yes,
Did they file it with the knowledge and permission of your client?
yes.
Even though Mr. Duckett was not an attorney of record in this case?
The answer is yes.
Okay. Now let's turn to ODC 21, which starts with 1422.
I'm there.
Okay, that's the order that Judge Rebrano entered into the record, correct?
That's accurate.
And he denied the motion for reconsideration?
Yes, not everything, yes.
Let's go to ODC 22. Is that Judge Verbrano's order denying the costs associated with the healing deposition?
Yes.
Okay. And did the judge mention that Mr. Nasamento, let me put that in there, that he's asking, even though he was off the case for a year, he's asking for attorney fees?
That was for the work that he did already. He didn't just file the motion, not based on any factual background. He wanted to be paid for the work that he performed. And I said he withdrew of that year ago, but he had came back. And there was still a lot of work being done behind the scenes. He wouldn't dare file a motion asking for money he did not earn.
And in this order, Judge Verbrano also talks about Mr. Duckett in regards to an attorney who has never entered his appearance requesting attorney fees.
That's correct. But Mr. Duckett did perform work for us when we prepared for that position. And the rules do say you can be compensated for reasonable fees.
And Judge Verbrano says in the footnote that the fact that plaintiff seeks fees on behalf of an attorney who has never been counsel of record and the attorney who withdrew his representation a year earlier highlights the unreasonableness of this request. You see that?
Yes, I read that. I remember that.
We're still on the same exhibit 22, right?
Yes, I'm sorry.
22.
22, and it's 1427,
Yes, thank you.
and it's the second paragraph in the footnote. Now, after Judge Verbrano denied your motion for reconsideration, you filed an appeal with the Third Circuit, correct?
That's accurate.
And the docket of the Third Circuit is ODC 23, correct?
It appears to be yes.
Now, the Third Circuit ultimately affirmed,
That's accurate.
correct?
That's accurate, yes.
And their opinion is, the Third Circuit's opinion is ODC 24.
This appears to be yes.
Now, I'm sure you remember when ODC sent you the DB7 in regards to the Murphy case. Do you remember that?
I remember receiving it. I don't know the exact date. I remember receiving it.
I didn't say the date. I just said
But
you
your
remember
question is very
receiving it.
open-ended.
Okay. Just have to argue with each other.
So let's put this over. So go to your ODC 52 is the DB7 letter that you sent, that you received from this office? ODC 52.
Just give us a minute.
No problem.
Just take it.
I'm there.
Okay, and that was sent in September 20th, 2023. Do you see that?
Yes, I see it.
Okay. And you filed an answer to the DB7, correct?
Yes,
and
I
that's
did.
ODC 53?
Yes.
And in your DB7 answer, on page 1862, you said, and this is at the last full paragraph, the fact that I refuse to sell out my clients, especially in a civil rights case, has raised the ire of some judges and opposing counsel. You still agree with that?
Yes, absolutely.
And then you went on to say, my representation of victims of government abuse has caused me to be targeted by some judges who are directly connected by way of family or association to the Philadelphia law and police departments. You still agree with that?
Of course I did. I said that, yes.
So as I asked you earlier in the testimony, at the time you were counsel of record for the Murphy matter, and when you filed it, you had only been out approximately 2 years, or admitted to practice law in Pennsylvania in 2 years.
And I had homicide cases overturned. I've done a lot in my little bit experience. Yeah.
Well, okay, I asked for the civil cases. How many homicide cases did you do between 2018 and 2020?
I don't know. Not a lot.
Less than 5?
Perhaps.
Okay.
I mean, on the record, yeah.
Okay. Okay, on 1863.
I'm there.
It says, to this end, it is common practice of some judges to use their position as an instrument of oppression to rig the scales of justice against civil rights plaintiffs and their attorneys. Mrs. Murphy's case is a prime illustration of this fact. You still agree with that?
Yes, I do, absolutely.
Okay.
And I didn't say all, I said some.
I think I said something, but that's okay. We're not gonna argue with that. 1865. It says, a review of these documents and their attachments reveal that Judge Rebrano's rulings are openly biased and purposefully discriminatory. So you believe that Judge Rebrano was openly biased against you and your clients?
Yes, absolutely.
Do you have any evidence?
You're gonna talk about him when Mr. Duckett does his direct, because there's documents to prove what I'm saying. I didn't just say that for no reason. I would not do anything like that against a judge unless I have a reason. So there's a reason for that.
Now let's look at 1868. Paragraph 22. So you also talk about Judge Rebrano's opinion is openly biased and contradicted by the evidence.
Yes, they are, and I can prove it.
Okay, everybody, thank Zach. Because I was not able to get this whole trial. It was 4 days long. And it wasn't like 2 hours each day. It was like 4, 5, 6 hours each day. And Zach got the whole thing. Sent me the whole thing. Thank you, Zach. I love Pennsylvania. Proposal. Okay, I'll marry you. It's fine. Sounds good. Let's do this. I expect a ring that costs more than $19.99. Because that's how much my first wedding ring cost from Sears. $19.99. And the marriage didn't last. And I'm thinking it was all because of the ring.
And if you go to the next page, it says Judge Rebrano should have recused himself from this case due to his pre-existing personal animus. You see that?
I see that, and there's a basis for it.
Okay, did you file a motion to recuse while this case was going on?
I didn't file the motion to recuse Judge Rebrano. I rarely file motions to recuse, because judges they do what they want a lot of times, and, you know.
You didn't, so the answer is you didn't file one.
No,
Okay.
no.
But if you wanted to, you could have filed one if you wanted to, correct?
You know, you
Yeah.
don't understand. You don't understand. I am extremely inappropriate in real life. Like, the words that come out of my mouth are extremely inappropriate in real life. I cannot drink while I'm on a stream. I cannot. Because I will be canceled. Nobody would, none of you, not one of you would come back when you hear what I really have to think. Not about you guys. I love you guys. Just about the world in general. You guys would never ever come back. I'm not going to say, nope, I'm just going to press play.
That's a yes or no. Now, when you filed your appeal to the Third Circuit, in your concise statement, you listed the orders that you are appealing. Was the September 27th, 2021 order? And if you need to go back to the docket to see what that was,
Where's exhibit? There's so many exhibits.
Exhibit ODC 1, Mr. Bell.
I see it, I got it.
And it's, September 27th, 2021.
Listen, I swear I would have to ease you into me gently because unfiltered, it's different. It's too different. I would have to ease you. I'm not mean. I'm never mean. I love you all. I would never say anything rude. I mean, I would definitely say rude things, absolutely, but not at you or to you.
Do you have, I found it. All right, so I'm at ODC 1. Do you have a date stamp?
September 27th, 2021.
What page is that on?
Let me get the book out.
It's like it's page 7.
Thank you.
All right, I am at ODC page, or Bates number 7.
Okay, and that was one of the orders that you appealed, correct? September 27th, 2021 order?
Okay. Yeah, I appealed. Yeah,
Okay.
we appealed everything except the sanctions motion, the sanctions order.
And you appealed the September 22nd, 2020 order by Judge Fabrino in your appeal?
I don't know what this was a minute ago. I appealed the decision to summary judge the case that he granted for the guy. I didn't even appeal the sanctions. I didn't even care about that. That wasn't my concern. My concern was him dismissing the case so my client could have a trial.
Okay. So you did not appeal the sanctions?
I denied it.
Okay. Now, anywhere in your concise summary of the case that you filed with the Third Circuit, did you mention your allegation or perceived, your allegation that Judge Fabrino was openly biased?
Why would I do that? I didn't file a motion to recuse. You had, in order to present any issue to an appellate court, you got to preserve. They require thorough preservation. It would have been a bad move to file a claim that was not preserved in the trial court. That's crazy.
Did you, and in your appellate brief, again, did you mention Judge Fabrino's alleged bias?
I would not do that because it wasn't preserved. And it wasn't even necessary. I had the Jones versus Flowers.
So when you when you submitted your DB7 answer to the for the DB7, that was the first time that you mentioned Judge Fabrino's openly biased attitude towards you and your client.
No, it wasn't. No, that was not the first time. I was complaining about that throughout some portions of the case. I didn't file a complaint about it, but you said complain. You didn't say whether I filed something. I was, I was complaining. I told my client about it. Yeah, absolutely.
So your complaint was to your client?
And to Mr. Nascimento, he was complaining too about how he let the city not file an answer.
Well, I'm going to object to anything that Mr. Nascimento said to you.
All right, well, I'm just telling you what you said. I wasn't complaining. I'm just communicating to you how I did complain. I'm not going to file a motion to recuse a judge. Judges do an important job. I'm not going to file a motion to recuse just because I don't like this ruling.
I get sick of this bulldog lawyer saying, well, why did you say this and why did you do this? And when he says, because this person said, oh, hearsay. Do you want to know why he did what he did? Or, I mean, hearsay doesn't count. He's not presenting the hearsay for the truth of the matter.
I'm not going to do that.
And did you hear him earlier? He was like, in a federal case, lawyers don't have to file a notice of appearance. They just have to file a motion, and that just automatically means they've appeared. Is that right? I mean, that makes sense to me, but...
So I'm telling you in this response to the DB7, I'm trying to alert you there was a problem. And just because a judge enters an order, that don't mean it's right. That don't mean it's right. So I was trying to communicate to you, and I gave you documents that if you would have looked at it, you will understand why I think that. I'm not just talking just to disparage a judge.
Okay.
I never just do that.
Other than your client and Mr. Nascimento, was there anyone else you complained about Judge Fabrino's openly biased attitude towards you and your client?
No, you gotta be careful when it comes down to talking about judges. Be very careful.
Okay. Okay, we're gonna move to the next case. This is the Miller case, and we're gonna start with ODC 25. So,
I don't know whose side I'm on in this. I don't. I can't figure out whose side I'm on. If he can prove the allegations that he's talking about, I'm 1,000% on his side. 1,000% on his side. But he starts talking about Chief Anders from Millersville. I worked with him for many years, and he is above reproach, so I don't know.
let me get 25 out.
Actually, is anybody really above reproach except for Terry? I know you are, Terry. I know you are.
And tell me when you have it.
I'm there.
Okay. Now, as I said, this is Mr. Miller's case. Let's go to 1449. Based in 1449.
I'm there.
Okay, now that's when, let's see, the matter here was listed for a case management conference, correct?
That's correct.
Okay, and do you recall when that was listed for the case management conference that you received information about what was needed, that what you needed to provide when the case management conference took place?
I'm sorry, what are you saying?
When you received notification
Yes.
of the date of the case management conference, do you remember receiving that?
I remember receiving the notice.
Okay. Do you remember receiving links to the case management template about what you needed to file 5 days prior to?
Thank you. I appreciate it.
I don't remember receiving links, but I'm well aware that you file case management memos to inform the court the nature of the case and stuff like that. But as you know, the complaint controls everything.
Okay, my question to you is, did you recall, you said you know about it already.
Absolutely, I know about
And
it.
so you know that they're requesting 5 days before the case conference, the case management conference, that you are to submit your case management memo.
And I comply with the law, as I always do, yes.
So 5 days.
I don't remember that, ma'am, I don't remember that. It was a
Okay.
case management form I filled, Judge Anders talked about it. So,
Okay.
yes.
And the conference was held on May 6th, February 6th, 2020. Well, look at the docket, Mr. Bell, so they can
Yeah, I'm not
refresh your
disputing
memory.
that. I just want to get to the meat and the potatoes, but yes, I did,
Well,
yeah, I remember.
I will get to the meat and potatoes when I get ready, okay?
All right.
Thank you. So anyway, the case management conference took place on February 6th, correct?
It took place. I
Correct.
remember it. I don't know the exact date.
Why don't you look at the docket? 1450.
February 6, 2020.
Okay. Now, when did you file your case management conference memorandum? You said you complied with the law. When did you file it?
I don't know.
Well, let me show you. And you already have copies of this.
We don't though, right?
You do not, no, but Mr. Duckett does.
Thank you.
Look up top. When did you file it?
It says February 6,
What time?
2003.
Okay, thank you. So this wasn't 5 days before the conference, correct?
If I'm a victim, I want her as the prosecutor. If I'm a victim. But that's why I keep calling her a bulldog.
Yeah, according to that state, but that wouldn't make a difference because the complaint controls the lawsuit.
Okay, that's not my question, Mr. Bell.
Okay.
Yes.
So if you look at 1450, The case management order was issued on February 6th at 3:18 p.m. You see that?
Yeah, this was the same day of the conference.
Right.
Yeah, and he scheduled a jury trial.
So the case management order, and you were here for Judge Anders' testimony, they use this to assist them when they have this case management conference, correct?
No, they used the complaint that
Okay.
filed. You said, what did you, so you talking about the law or you talking about what happened here?
I'm
There's a
talking
difference.
to Mr. Bell.
You didn't specify.
Mr. Bell, I said to you, this case management conference memorandum, as Judge Anders testified to, assists them in regards to determining whether or not this should be arbitration or jury trial. Do you remember his testimony?
I recall that.
Okay,
yes.
thank you. And in this case management order that you filed on February 6, 2020 at 2:03 p.m., they asked you a list of questions, correct? Do you remember that?
I know what a case management form looks like. I don't have it in front of me, but I know what.
Oh, okay.
Hey, it's fine. It's not necessary. I'm not playing. Look, I'm not playing games here. I know what's in that form, and I know what's
Okay.
required.
And you agree that you didn't fill out most of this information on here?
First, that's it.
Okay, well, you know what, Mr. Bell, let me ask you specific questions, so
Yes,
we.
please. Thank
Okay.
you.
Is there any permanent injury claimed? You did not check yes or no, but you said psychological trauma. Do you recall that?
That's what it. Yeah.
Yes or no?
Yeah, it would have had to be. Nobody got their hands chopped off or nothing like that
Dates of medical treatment, you put NA, correct?
at the time. There was medical treatment later, though.
Has there been an inpatient hospitalization? You checked no.
Correct. There was none of that. Yeah.
Has there been any surgeries?
Nobody got.
You left that blank.
Yeah, it was. Yeah, that's accurate.
Approximate medical bills to date, you put NA.
It was early in the case.
Hanky panky, Mom. Nobody listens to the stream. That's why I keep saying what's going on so that people refocus.
Approximately medical bills were recoverable in this case, you put NA. You recall that?
Yeah, I wouldn't make a false statement on that. Because
Time-
I didn't have that in front of me.
Time lost from work, NA. You recall putting that?
I put that on there, yes.
Approximate past lost wages, NA.
That's accurate.
Okay? Now, is there a future claim for lost earning capacity? You did not check any boxes.
Because at the time, I didn't have a basis to allege that.
Are there any related cases or claims pending? You did not check a box on that.
I didn't know, I just got the cases.
Do you anticipate joining additional parties? You did not check that, correct?
It was very early in the case. I'm not gonna list that. And then you can amend your complaint later on. So the complaint controls, I know that.
Thank you. Plaintiff's factual position as to liability, and this is what you stated. On or about March 23rd or 29th, 2018, defendant arrested plaintiff for robbery merely because plaintiff was sitting next to a robbery suspect. Defendant arrested plaintiff even though he knew plaintiff had no involvement in the robbery. Defendant thereafter confiscated plaintiff's lawful firearm and caused plaintiff's firearm license to be revoked based solely upon defendant's false arrest of plaintiff. Does that sound accurate, what you put
Yes,
there?
but we found out that's not accurate.
Okay, I'm
It
just
was-
asking.
It was just worse than I thought it was.
Mr. Bell, I'm just
Sorry,
asking you,
Ms. Hammond,
but he's not answering my question.
let him finish answering the question. Don't cut him off in the middle of the answer.
Okay,
So that was not 100% accurate because it was worse than I thought. But
okay.
that's what I knew at the time.
So you demand in excess of $50,000.
Yes, on false arrest and assault and battery, yes.
So you heard Judge Anders testify that what he had before him was this case management conference memorandum. And he also had the case management conference memorandum that was submitted by staff.
Yes.
Okay. So based on what Judge Anders had, you recall that Judge Anders testified that it did not seem like it would reach the threshold from arbitration, that it would be $50,000 or less. You recall Judge Anders saying that? Or testifying to that?
I recall that.
Okay, so you just testified that some of these questions you didn't answer because the case wasn't fully developed yet, correct?
But the law doesn't.
Okay, Mr. Bell, I didn't ask you that question. My question was, you just testified that some of these questions that were on this case management memorandum could not be answered because the case wasn't fully developed, correct? Yes or no?
At the time, yeah, I'm not going to lie in that report, but I've complied with 1021C and the arbitration statute. That's why he scheduled a jury trial. It takes it out of his hands. The judge cannot make a subjective ruling on something like this. You cannot determine the value of anything before you have a hearing or something like that. And the case law is very clear. Very clear.
Well, thank you for your answer, Mr. Bell.
Monica,
Yeah.
thank you for the cheers. Thank you, thank you.
Now, we agreed that ODC 26 is the complaint you filed in the Miller matter.
It appears to be, yes.
Okay. Now, at the time that you filed this complaint, was the case fully developed?
No, the case could not be developed.
Yes or no?
No, Ms. Hammond, let me answer the question.
When you file a civil complaint, that initiates that gives the court jurisdiction to hear whatever you're claiming. You have to properly plead your complaint. That's why they have like the well-pled complaint rules and stuff like that. You gotta know you have to know what to say in order to trigger the court's jurisdiction. And what I did was, in this complaint, we listed the essential facts necessary to require under the arbitration statute and in compliance with 1021C. We allege everything necessary to entitle us to a jury trial. And I did not have every single fact of the case because these clients came to me literally like a couple days before the times of the statute of limitations expired. I think it was on Miller, I think it was on Myers, one of them. So I had to get them filed right away. And so everything listed here is not everything that I subsequently found out about the case after discovery. Because once you file the complaint, then it goes to the discovery phase. So yes, you can ask for discovery.
You look like a neon green shag type of guy. So is that better?
And right after the complaint is filed in Pennsylvania, you can't ask for depositions. You got to wait to the case management. However, I was waiting to the scheduling order to be issued so we could commence discovery. Me and the city, we didn't even touch discovery until the court entered its case management order outlining the discovery deadlines.
You can get that on Temu for $7.81 right now. There you go.
Everything.
Bill,
Yes.
I want you to be able to answer Ms. Hammond's questions.
Okay.
I don't want her to cut you off in the middle of the answers.
All right.
That means you have to answer the questions.
Okay, yes.
Mr. Duckett's going to get to ask you questions later.
Okay.
But you need to answer the questions she said.
Absolutely.
And if I may, I know Kim is an amazing court reporter, but Mr. Bell, for the court reporter's benefit, if you could just slow down in your response, that way we will be able to hopefully have her all day.
He can't slow down in his response because his lawyer keeps talking over him. He's trying to answer the questions and she keeps interrupting him. Sorry.
And her hands won't be aching. I appreciate that. Thank you.
How long have we been going this time, Ms. Henderson?
We should probably take a break within the next 5 to 10 minutes. I was waiting for Attorney Ammons to get to a good stopping point.
Are you gonna get to a new area soon?
I'm going to still talk about the Miller case, but we can take a break now if you would like. I still have questions on Miller, so.
What do you think? Let's do another 5 or
Okay.
10 minutes, but then when we get to a logical stopping point.
Okay, that's fine, okay. Mr. Bell, ODC 27, which is 1469, that's a case management expedited track order, correct?
Yes, it appears to be.
Okay. And then ODC 28. That's the order Judge Anders entered, putting the matter of Miller versus Holter in arbitration. Do you see that?
Yes, I see it.
Okay. And as you heard Judge Anders testify, that the reason why he put this in arbitration was based on the case management conference memorandum that you filed. The case management memoranda that Mr. Hubbard filed, and also the report from the staff. Do you recall him testifying to that?
Yeah, I remember him testifying.
And you recall him testifying that this is the only information that he had in regards to evaluating whether or not this matter should go into arbitration. You recall him testifying to that?
I did, but that's not accurate.
Okay,
Like, yes.
thank
said
you.
that.
Thank you. He did say that. Thank you. Now, what I neglected to ask you earlier, when I asked you when you filed your case management conference memorandum, do you recall Judge Anders testifying when the city solicitor filed theirs?
I don't
Okay.
remember that.
Do you want to see a copy of it? I'll show you a copy. Since you didn't file yours 5 days before the conference,
That's
What-
not a question.
what date was Mr. Hubbard's management file?
It says, January 21st.
Okay.
So I don't have a copy of that.
I did, no, you don't have a copy of it. I showed it to you the last time we were here. And no, you don't have a copy.
Next time you do that, make sure you show it to him first.
Okay, I neglected because I did show them before, but I will do that. Thank you so much for reminding me. Now, after Judge Anders entered this order, you filed a motion to remove the controversy from mandatory arbitration to reinstate previous scheduling order is hereby, well, you filed a motion, and that's ODC 29?
So what she's talking about is he had a case, they were supposed to go to arbitration. He told his clients, don't go. He didn't show up. Nobody showed up to arbitration. The judge, by default, ruled in favor of the plaintiffs, and they won. And then he wanted to appeal it.
Yeah, that appears to be the motion.
Okay. And it was assigned to, I think, Judge Patrick? The motion?
Yes, Jay, Judge Paul Patrick? Yes, yes.
Okay, 20, if you want to refresh your memory, you can look at the docket. Now, before Judge Patrick order granting your motion was entered on the record, the arbitration center scheduled arbitration, correct?
I don't recall.
He is also accused, the reason why he's getting disciplined is he accused a bunch of judges of being racist. So we're going through each of the cases and the judges that he accused of being racist.
I don't know, like, when exactly what. I just know the big ticket items. The motion was granted.
Do you want to refresh your memory by looking at the docket?
If it's necessary for you to prove your case, I will
and a
assist you
police
with that.
chief.
Can we ask Mr. Bell to stop with the commentary and just answer the questions?
Well, I mean, you do have to answer the question, Mr. Bell, but Ms. Ammons, I do wonder about why we need to keep asking
They're adult
witnesses about the
diapers.
dates of documents that presumably you're going to admit into
Okay,
evidence. If it matters for the questioning, then of course, and you got to answer the questions, but you did ask Judge Anders about all these, and now you're asking Mr. Bell, and I presume you're going to offer these into evidence, so we could probably move it along a little bit.
okay, do you recall getting a notice that the arbitration was scheduled?
Yes,
Okay. And you made a decision that you were not going to appear for the arbitration.
no, I did not make a decision. My clients made a decision.
And did you advise your clients, are your clients attorneys?
Last I recall, they're not.
Okay, so would you agree that your clients were relying on your advice as
I
your
gave-
as their legal counsel?
And they received good advice.
Okay. And you advised your clients not to appear at arbitration?
I didn't advise them to not do that. I told them what their options were. Like they had the arbitration statute, they had the case law interpreting statute, they had Rule 1021, they read that, and I told them, you don't, look, the law says, according to the arbitration statute, you're entitled to
I handed them a law book and I told them to decide. What do you want me to do?
a jury trial. And they understood that. They did not want to litigate their case for less than $50,000. My clients made their choice.
Did you tell your clients the consequences of not showing up for arbitration?
Yes,
And what were those consequences that you told your client?
they're going to enter, the court's going to enter a judgment, and then you can appeal and have a trial.
Did you tell your clients that if you don't appear for arbitration, that is the judgment of the judge is not appealable?
It is appealable. It is. This is the only
Okay.
case, but we'll talk about it. It's
Okay,
absolutely appealable.
okay. So after your clients fail to appear, and after you fail to appear, non-pros was entered, correct?
Correct.
Okay. And then you filed a motion, I believe it's ODC 30. Let me, wait, before you do that, strike that. ODC 30, let's backtrack, is your motion to recuse Judge Anders. ODC 30.
All right, I'm at ODC 30.
Okay. And in ODC 30, you made several allegations against Judge Myers being biased against your client because of their race, correct?
Judge Anders,
I'm sorry, what did I say?
Judge Meyer.
I'm sorry, Judge Anders. You made various accusations against Judge Anders in your motion to recuse.
I made the argument, and I never said he was actually biased. I said it appears that there's a big difference. I never said, I don't know Anders. I don't know I don't know him. I just know based on his conduct. In addition to the Jarvis case, because I'm aware of that. And
I said he appears biased. I didn't say he was biased.
Jarvis is a plaintiff in these cases.
Okay, we're not talking about
All right,
Jarvis,
all right,
we're
okay,
talking about
all
Miller, okay?
But they were filed at the same time.
Okay, but we're talking about Miller, we're not talking about Jarvis.
Okay.
So in the Miller case, you stated that, as I said, you made allegations against Judge Anders being biased against your clients, correct?
I made an argument. I never accused him of being, because I don't know him. And he determined the value of their cases without a hearing or anything based on Mr. Hubbard saying the cases ain't worth nothing.
Okay.
Presented red flags to me.
So it's red flags because he ruled against you?
No, absolutely not. I don't care that. I don't care about that. It's that the process. You're supposed to have a hearing, get discovery. It's just it was placed in arbitration based solely on what Hubbard told him to do.
Okay, let me ask you a question. How do you know, are you saying that Mr. Hubbard specifically told Judge Anders that he had to place this in arbitration based on the color of the plaintiff.
Based on the color of Hubbard would.
The race of
Yeah, Hubbard wouldn't do that. He's too smart. He told Eric Orborg, your coworker, to put the case in the arbitration.
He told Eric Orbitt to put the case in arbitration.
Right.
Okay? And you told Eric Orbitt that you wanted the case to be sent to a jury trial, correct?
Yeah, yes.
Okay. So, what evidence besides, you said you don't know Judge Anders, besides Judge Anders deciding to put this case in arbitration, what evidence did you have that Judge Anders was racially biased against your client?
What evidence did I have to support my
At the time. I'm not talking about now. At the time.
question? I mean, okay.
Answer the question.
The prior dealings with Judge Anders in the Payton case, that was only 2 years prior, about 2 years prior. And how he ruled without having any type of evidence whatsoever. It appeared to me that he was retaliating from the last case because he was talking about a newspaper. It appeared to me. And you don't make a ruling on the evidence without having any evidence to base the ruling. In addition to that, the arbitration clause is exceptionally clear about the limit.
That's not the way marriage works, though, guys. Don't worry. You don't need evidence.
I'm telling you why.
You asked why, you gotta let him answer why.
I did not just come up with this out of nowhere. It appeared. That's why I never said he actually was. I don't know, but I know what it appeared to me because I've seen his conduct in the past, and then I've seen and Halbert was the same lawyer on the prior case too. It's a whole saga. So it was based on the information I had, and he just seemed to overly biased. And then you just ignore the arbitration statute, and you determine the value of 3 people's cases with no hearing or nothing. To me, this looked kind of, and I know that the reputation of the Philadelphia Court of Common Pleas, the reputation ain't the greatest. Respectfully, I'm not trying to say all judges are bad, but well, man, this court's kind of, don't got a good reputation for treating people fairly, and did I answer your question?
I don't know, but let me ask you another question. As we mentioned before, you had this motion.
Comments, let's take a break now,
Okay.
and then we'll resume after that. So 10 minutes.
Sounds good.
All right, guys. That was part 1. We're going to keep going tomorrow on part 2, which is the end of the first day. So tomorrow we'll end the day 1. There's 4 total days. I don't know if I'm going to play all of it. If it doesn't stay spicy, then I'll cut it out. But it doesn't look like I'm going to cut a lot out. So it could possibly be 6 more days of this. We'll see. 7. So I know how to count. 7. So in 6 hours, we'll go at round 2. 6.5, something like that. Thank you so much for coming out today. We had a great crowd tonight. Chat was amazing. I can't wait to go back and read what I missed. And I'll see some of you tomorrow morning at 4:30 a.m. Eastern Standard Time. Bye, guys. Have a great night. Behave, okay? Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see